For so many franchisors, the legal process can be frustrating. You spend a ton of time, money, energy, and resources on franchise development. You're attracting qualified franchisee candidates. You're involved in the conversion and onboarding process, and along the way come legal obstacles. No matter what they are, the legal obstacles all have the same thing in common. They cause frustration, they're causing friction, deal friction, and worst of all, they may be costing you deals. They may also be a sign you're not getting the legal support that you need. And we're going to discuss 3 reasons why your legal team may be costing you deals. So the 3 reasons why your legal team may be costing you deals: 1, your FDD does not meet best practices. It's just not competitively positioned. Second reason, your registrations are delayed. You go dark. You can't sell. Third, something comes up often. You find that attorney communications, access, turnaround, they take too long and they're costing you deals. And we're going to dive into all 3 of these reasons. First is your FDD does not meet best practices. You're not competitively positioned. And in a world where franchise brokers play an important role, your FDD needs to meet best practices and really communicate differentiating factors for your franchise brand. No matter how great your franchisee attraction, education, discovery, and sales processes are, no matter how much we try to avoid it, your FDD plays a critical role in the franchisee recruitment process. It's front and center. Your FDD is there. Brokers, broker organizations, they're going to look at your FDD compared to other competitors. Your candidates are going to look at it. If there's frustration, if there's something missing, silently or without knowing it, you may be losing out on deals. You're going to have leakage in your franchise recruitment bucket. So when we talk about best practices, some of the most important factors are an industry best item 19. Most franchisors have an item 19, but a lot of them look alike. They don't give the information you'd want to see, and many are poorly organized. You really can't understand them. They're sort of confusing. Transparency in your item 19 is critical. A well-developed item 19 is an absolute priority. And think about it. You know the questions that brokers and franchisee candidates are going to have. So you have to go beyond the typical gross sales item 19, right? We need to be showing data about year-over-year growth, same-store sales, profitability, cost of goods sold, cost of services provided, gross profit numbers, even other metrics. If you're a service-based business, what do lead generation costs look like? What are conversion ratios if you have a call center? What's that data and information that's missing in your competitor item 19s that are going to give you a competitive advantage? And most important, give your candidates real visibility and clarity as to your financial data, right? It's all about transparency. It's all about best practices. Your item 19 shouldn't be a block of confusion. It needs to be clear, precise, well-defined, and really industry-leading data that franchisee candidates and brokers can evaluate. And I'm going to give you a hint here. If you're doing your item 19 or planning it out with your attorneys in November, December, January, you're not going to have a good item 19. And we'll talk about that in a couple of more steps. Now, industry best practices, right? Your lawyer may be costing you deals because your FDD does not meet best practices. One example is item 19. The second is multi-unit strategy. We all know that brokers and even franchisees like to evaluate multi-unit franchise opportunities. So if you're a restaurant or brick and mortar, it's your multi-unit development agreement. If you're a service-based business, it's a multi-territory structure in your FDD. You need to have it. But not only to have it in place, it needs to be clear. It needs to show those volume discounts. But also on the franchise growth end, let's forget about franchise sales right now. We also don't want to be selling too many franchises to either an underperforming franchisee or franchisee that can't grow territory adequately. So what are the safeguards we put in place? Well, from best practices, if we're doing multi-unit development or multi-territory franchise sales, then we also need to consider protection devices, right? Really good structure in terms of minimum royalty structures, maybe performance requirements, maybe operational requirements. When do they have to implement a second service vehicle, a third service vehicle? What targets do they have to hit? I mean, remember, as a franchisor, your future value is the EBITDA valuation of your system, which should be in years from now dominated by royalties. So we want to make sure we implement that multi-unit strategy, but we're also protecting the system long-term and not have underdeveloped territories or underperforming franchisees. Best practices? Well, it's an evolution also. Franchising fairness. As your FDD evolves over time, you and your franchise lawyers should know the pain points, the frustration points that franchisee candidates have. You should also understand potential advantages you could gain against your competitors. So along the way, it's important to introduce franchising fairness provisions into your FDD and your franchise agreement, whether it's allowing for multiple renewal terms, whether it's lowering your renewal fee, whether it's achieving, putting in provisions for common requests about estate planning goals and other franchisee requests that seem reasonable. This is stuff that should be tracked throughout the year. So the first issue, where your lawyer may be costing you deals, you're not meeting best practices. Second, is so common and so obvious. Your registrations are delayed, you go dark. And then it becomes a game of everyone blaming the other, whether it's a delay in your audit or it's a delay in you getting information to your lawyer. But the reality is there should be a process in place for renewals. Renewals shouldn't start, conversations shouldn't start in November and December. They should start after the first half of the year. June 30th hits, you go into FDD update and improvement mode, meaning you should be working with your lawyer, structure it out. You now have 6 months to develop the very best FDD, and your attorney should be leading the way. At the end of June, start planning out what a better item 19 can look like. Your attorney should be modeling that out, providing it to you. Why? Because there may be data you're not collecting, or maybe data you may need to do a better job of collecting and communicating with your franchisees, right? You don't want to get to November, December, January, have what could be a great item 19, but then not have the time to get the data from your franchisees. So planning is critical. Early communication with your accountants, modeling out your FDD updates. This should all be done. You should have a working draft of your fully updated FDD by November, December. This includes a fully updated item 19, and then come January, when numbers settle in and come in, your FDD gets completed, you're ready for registrations and filings, you're maximizing your opportunities, and you're avoiding the delays, and you're avoiding going dark. Other ways to avoid that? Well, when your attorneys receive comment letters, it needs to be a 24-hour turnaround. You can't afford any delays in responding to state regulators. As many delays as possible, you should be anticipating, right? Your FDD state-specific amendments and FDD amendments should meet best practices, be current, anticipate what the regulators are going to ask, and just create a seamless process. So second way your attorney may be costing deals, they're not planning out the process the right way, and your registrations are getting delayed and you're going dark. And there's accountability all around, but your attorney's quarterbacking this. And so process needs to be in place. It needs to start at least 6 months before registrations come up. Renewals, I should say. Third is something we hear often, and it relates to attorney communication, access, and turnaround. It just takes too long. Many times we'll hear, I like my franchise lawyer. I think he or she's really bright and good, but they're not turning deals around. They're not responding quickly. I can't access them when I need to, and it's killing deals. And so we hear this frustration often. And why does it happen? Well, first and foremost, you're closing franchise deals. Your franchise lawyer's role, our role as a team, is to help you close deals and provide you with the support and resources to grow your franchise system. So that means you need 24-hour turnaround on getting FDDs out. Well, FDDs have to go out right away, 24-hour turnaround on getting franchise agreements out, addendums out. If you're negotiating, clearly communicating with franchisee counsel by email, documenting everything so you don't have the attorney phone tag, right? But also always accessible. You need a team that's always accessible. right? So for at the franchisor level, you need a support team that has dedicated team members to your compliance, to your franchise agreements, and to the day-to-day activity you need support on. Now, why may you not be getting the right support? Well, it could be a couple of things. One, your franchise lawyer or firm may not be a franchise-only law firm. That could be a problem. The other is they may be, but they may not be built for emerging brands. You're an emerging brand. Whether you're at 0 units or 115 units, closing deals are a priority. You need to be a top priority. And so you need a law firm that places complete value and priority on serving emerging brands and helping them grow. So those are the 3 reasons. There's probably others, but there's a good chance one of those 3 or all 3 are costing you deals. And the worst part is it's not only the deals that you see fall apart last minute, but it's the deals that never get through the first stage. Whether it's a broker that doesn't refer because they're not crazy about your item 19, or a broker that just found your process frustrating. So take a look at these and build out a better relationship with your lawyer and get the right support.